I will put our website in later, and you can check out our website for all of our events. We're going to stay muted. We are going to record. So if you do not want to be on the recording, or at least your face on the recording, please shut your cameras off. And I think that, oh, the other thing is, if you have questions, we will answer questions after Peter's presentation. Please put your questions in the chat, but we will also take questions if you raise your hand later on. And now Bob is going to introduce himself.
Thank you, Lavina. Good afternoon, everybody, and thank you for joining. My name is Bob Jackson. I'm a member of the GLAAS Club in the active adult retirement community here at Saddlebrook. The acronym GLAAS stands for Gays, Lesbians, and Allies at Saddlebrook. And the mission of GLAAS is to use the power of community and camaraderie to celebrate the lives of lesbians, gays, transgendered people, and their allies. So next, I'll ask Beth Meyerson to please introduce herself and our distinguished guest speaker this afternoon.
Thanks, Bob. Good afternoon, friends and colleagues. Thank you so much for the invitation to be with you today. And Bob and Lavina, thank you so much for that invitation. My name is Beth Meyerson. My wife, Jill, and our son, Jake, and I, we are Tucson, Oro Valley transplants, so fairly new to this area. I'm a research professor at University of Arizona, and I serve you as a member of the Lambda Legal Board, National Board of Directors from Arizona. I and my colleague, Bill Hardin from Phoenix. As many of you know, Lambda Legal, founded in 1973, is the oldest and largest national legal organization whose mission is to protect the civil rights of LGBTQI+ populations in the US and everyone with HIV through litigation and policy work and education. Now, as a nonprofit, you probably don't even realize we don't charge our clients for legal representation or policy, and we receive no government funding. So we depend upon contributions from supporters across the country to do the great work that you'll hear about today from Peter Renn. So it's my distinct pleasure to welcome Peter Renn, counsel at Lambda Legal. Peter was part of the legal team that won the freedom to marry for same-sex couples in Nevada and established the appellate precedent, which led to the marriage equality throughout Western states, including Arizona. In fact, Peter, without your work, I would not have been able to marry my wife, Jill, even though we had been married not from a state perspective years ago, and immigrate with my family to Switzerland, where we lived for 3 years. I would not have been able to go without that legal document between us. So thank you for that. Both before and after the achievement of marriage equality, Peter fought to ensure that all same-sex couples, whether they're married or not, have access to those protections as they should for their relationship, even when they were barred from marriage. He'll be talking a little bit about why this fight's not yet over, and we'll answer questions that you have after the presentation. So Peter, it's yours.
Thank you so much, Beth, and thank you, Lavina and Bob, and everyone who helped to put this event together. It is lovely to be here with all of you virtually this afternoon, and thank you for choosing to spend an hour out of your day learning about some of the work that we've been doing at Lambda. I will also say that Tucson has a special place in my heart because the last time that I got on an airplane was for the hearing in this case, which was now more than a year ago in March. And so for me, at least, Tucson is a reminder of what life used to be like before the pandemic. Maybe not for the rest of you, but at least for me. So the case I'm going to talk about primarily was in Tucson, but it's gone on really to have nationwide impact. And let me see if I can turn on my PowerPoint slide now. Okay, I am hoping that you can see the screen if someone could, okay, terrific. So it's a privilege to talk to you about this work because this is an issue that has harmed a number of people in our community, but yet not a lot of people seem to know about it. And I think that there is a misconception out there that We fixed everything that there was to fix with marriage equality back in 2015. But the reality is that we have some unfinished business because there are members of our community who've been suffering harm. And that legacy of discrimination is something that we are still dealing with and trying to unwind as best we can. And I will also say I've been at Lambda Legal now for more than 10 years as an attorney. And this work that I'm going to talk about has been some of the work that I've been the most proud and privileged to do, because to me, this work is part of our collective commitment as an organization and really as a community to make sure that we don't leave anybody behind. I personally also have a marriage certificate because of the work of the movement. Unfortunately, though, some people either didn't have the benefit of that justice, or it came too late. So let me see if I can change my slide now. Okay, so as I mentioned, what I'm going to be focused on is really two pieces of litigation. The cases are called Ely versus Saul and Thornton versus Saul. And they both deal with the same issue, which is that the surviving members of same-sex couples, some of them have been denied access to Social Security benefits by the federal government, which they would have received if they had been heterosexual different sex couples. And so the basic requirement that underlies this particular benefit is that the government requires you to have been married for 9 months. And the problem that some members of our community have faced is, well, what if you weren't able to be married for 9 months? And that's what these cases address. The first case, and the case that I'll be focused on, Ely, is a class action on behalf of same-sex couples who were able to marry, but they weren't able to marry for the full 9 months required to access Social Security survivor benefits. The second class action that I will also talk about is on behalf of same-sex couples who were not able to marry at all. And both of these cases really sit at the intersection of two different priorities for Lambda. One priority is our work on behalf of same-sex couples and making sure that they are treated equally and receive the same respect as different sex couples. As I mentioned, even though we've won marriage equality back in 2015, that did not fix everything for everyone. And just because the cameras have left this issue in some respects, it doesn't mean that our work is done. The second priority that these cases touch upon for Lambda is our work on behalf of seniors. And we know, unfortunately, that members of our community tend to be less economically secure than their non-LGBT counterparts for a whole host of reasons. Some of that includes the history of marriage discrimination, which I'll talk about. It also relates to oftentimes a lifetime of employment discrimination and having less support from family. And all of that contributes to economic vulnerability. And so this work that we are currently engaged in is trying to fight back in the ways that we can with respect to Social Security benefits, which are obviously an incredibly important source of financial security for all older Americans. So before I dive into the facts of the individual cases, I thought I would do a quick recap of sort of our journey to marriage equality as a country. And this slide recaps some of the sort of key milestones along the way in that journey, just so you have it in the back of your minds when I talk a little bit more about our plaintiff stories. And I'll just point out a couple of notable dates on this timeline that you see. One is that 50 years ago now, there was a case called Baker versus Nelson, and it involved a same-sex couple in Minnesota that tried to get married. They were denied, and they appealed their case all the way up to the Supreme Court. And the Supreme Court dismissed the appeal because at the time, it didn't even think that there was a debatable question about whether excluding same-sex couples from marriage was unconstitutional. So fast forward many decades to 2004, to the first state in the country that allowed same-sex couples to marry, which was Massachusetts. And that was as a result of state court litigation. Over the next 10 years or so, we saw an increasing number of states allow same-sex couples to marry. Oftentimes it was the result of litigation. Sometimes it was the result of legislation. You'll see that 2014 is here because that is the year in which Arizona finally allowed same-sex couples to marry. And that was also thanks to a Lambda Legal case that my colleague Jenny Pizer litigated. And then finally, we have at the very end of this particular timeline, the 2015 decision in Obergefell, in which the Supreme Court recognized that all same-sex couples have a fundamental constitutional right to marry. And the most important takeaway I would say about this slide is that the work of the movement, even with respect to this particular issue of marriage equality, it didn't really end at 2015. And as I'll talk about, there's actually ongoing work that we are currently engaged in to make sure that equality is actually real for everyone in our community. And the central issue that these cases that I'm going to talk about relate to essentially is how long were you together? And I think that's something that many same-sex couples can relate to, because if you ask a couple that's been together for quite a long period of time, they may have a more complicated answer than a heterosexual couple who is able to say, oh, I was married for 10 years or 15 years. Oftentimes, I feel like for people in our community, it comes with some caveats and explanations. Well, which anniversary are you talking about? The anniversary where we met or we moved in, or is it actually our wedding? And so let me go on to the next slide and tell you a little bit about how that sort of dilemma has affected our client, Michael Ely. Okay, so this is a picture of our client, Michael, on the left. And he's pictured with his late husband, who went by the nickname of Spider. And this photo was taken in 2013. And I hope that you will indulge me in telling you a little bit about their relationship, which I think is just a really beautiful love story. And it exemplifies the type of relationship that I think many people would aspire to have in their own lives. A picture is worth 1,000 words, and I feel like these 3 pictures are worth 3,000 words. Michael met his ultimate husband, Spider, in 1971, when he was only 18 years old. He had hitchhiked to a bar in Sunset Beach, California, right off the Pacific Coast Highway. And he was sitting there at the bar when somebody tapped him on the shoulder and asked him to dance. And that man was the man he would one day marry, Spider. And his nickname was Spider because he was always climbing up the walls as a little kid. And so that's a nickname that his father had given him. And Spider was 20 years old at the time. They both had fake IDs, which is how they got into the bar. And in fairness, there weren't a whole lot of places for gay people to meet one another. So that's what they did. They danced, talked, shared a kiss goodnight. And after that one experience, Michael felt that he had met his soulmate. And I will say probably a lot of 18-year-olds feel like they've met their soulmate, but as it turned out, Michael was not wrong. And this is the man that he would actually end up sharing the rest of his life with. And at the end of the night, Spider wrote down his number on a little pink piece of paper and gave it to Michael. And that's a piece of paper that Michael still has to this very day. They moved in together in December of that year. And for a long time, that was the date that they celebrated as their anniversary, because they had no other date they could celebrate. One of the things that they also bonded over was their love of music, which you may not be shocked by when you see the pictures of Spider's hair, but they went on to actually play in multiple bands together. So Michael usually was the singer in the band. He's pictured here in the middle. Spider was the one who usually played the guitar. And they had a very, very good life together. Spider was the breadwinner in the family. He worked as a jet mechanic, and Michael ran the household. He used to tease Spider that he couldn't even boil water. And I think that's also something that many of us can relate to, that in a relationship, there's often the chef, and then there's the person who eats the food. So they met in California, but they ultimately moved to Arizona in the 1990s. They adopted a dog named Frappy. And as I mentioned, life was good, but they also experienced their fair share of discrimination. So for example, there was one time when Spider was hospitalized with pneumonia in the 1970s, and Michael was only allowed to see him for an hour a day because he wasn't considered family by the hospital. They also had coded language they would use to express their love for one another in public in situations where they didn't feel particularly safe expressing their love. And the shorthand was to say, don't forget, which was shorthand for saying, don't forget I love you. So like so many couples of their generation, they wanted to marry, but they couldn't. So this next slide sort of chronicles their journey to ultimately getting married down the road. In 1973, so 2 years after they had met, they were witnesses to their friend's wedding, and their friends are the heterosexual couple pictured here in the middle. And someone else at the wedding joked that, you know, now don't the two of you run off and get married. But of course they couldn't. In 2007, so well into their relationship, they decided to have a commitment ceremony because that was the most that they could do at the time. And they exchanged rings that were engraved on the inside with the words, "Don't forget," which was again their shorthand for saying, "Don't forget, I love you." And it wasn't until finally 2014 when they were finally able to tie the knot more than 40 years after meeting. They got marriage licenses within 5 days after same-sex couples could get such licenses in the state of Arizona. And then they gathered together a group of their loved ones and they got married less than 2 weeks after they got their license. And that picture in the lower right-hand corner is of them exchanging the same rings that they exchanged at their commitment ceremony in 2007. Unfortunately, this was also very much a bittersweet moment for them because the year before their marriage, Spider had been diagnosed with cancer. And he tragically did not live to even see his 1-year wedding anniversary because he died 6 months after they were able to marry. And I think this quote from Michael is such a beautiful quote that sort of describes how the loss impacted him. He was talking to a music publication and he said, "Loss is the hardest thing we deal with as people. It leaves a big hole. At my age, you have a lot of holes. In fact, I feel like a piece of Swiss cheese, but I try to embrace those holes because each one reminds me that I was loved, that I have loved, and that I am loved." So obviously the loss of the spouse is emotionally devastating, but it also has dramatic financial impacts on the survivor. And that was particularly the case in Michael and Spider's situation because again, Spider was the breadwinner in the family and Michael ran the household. And so one thing that really lessens the impact of the loss of a spouse is Social Security survivor's benefits. So what are Social Security survivor's benefits? These are the benefits that basically allow you to collect Social Security on the work history of your late spouse. So you're eligible for them starting at age 60, which is 2 years earlier than your retirement benefits. And you can also collect them a little bit earlier than that, even if you are disabled. But one of the benefits of collecting Social Security survivor benefits is that it allows you to delay collecting Social Security on your own work history. So it's particularly consequential if you are the lower wage earner in a relationship, but even if you aren't, it can still be quite beneficial to you to collect Social Security survivors benefits. The important thing to keep in mind, though, is that much like Social Security retirement benefits, these are not funded by general tax revenue. These are funded by the contributions that you make from your own paycheck to the Social Security system. And so, during his entire working career, when Spider was a jet mechanic, 6% out of every single paycheck went to Social Security. And the purpose of that contribution is not only to fund your own retirement benefits, but also to fund the benefits for your surviving spouse that you leave behind. But the catch is that you need to have been married for 9 months in order to access these particular benefits. And the reason for that general rule is that the government doesn't want people entering into fraudulent marriages merely to pass off the right to collect Social Security survivors benefits. So when Michael went to apply for these benefits, no surprise, he was denied. He applied at age 62 when he was eligible, and he was denied on the grounds that he was married for less than 9 months. And I will say this was not an unexpected outcome for Michael. Before they had gone into the Social Security office to apply, and when Spider was still alive, they had gone down to the Social Security field office. And at the time, Spider was in a wheelchair, and they wanted to make sure that there was some way that Michael could access these benefits. And the staff person that they encountered said, "I'm sorry, but we have this rule that requires you to have been married for 9 months. And it's the same rule that we apply for straight couples and gay couples alike." To which the response is, but it's not the same rule, because of course, same-sex couples like Spider and Michael weren't able to be married in the state of Arizona for 9 months. So the cost of this denial to Michael is really quite astounding. Some of these are approximate numbers, but they give you a sense of what's actually at stake. So assuming that the benefits at issue are worth $1,750 a month, that comes out to $21,000 a year. And if you assume just an average life expectancy, the total amount of benefits that someone in Michael's situation would have been denied is $336,000. And again, this is a denial of the money that these couples paid into the system. This is not government largesse. This is your own money, essentially. And so in a very real sense, this is, for Michael, the price of being gay. He was deprived of more than $300,000 in benefits because he was in a same-sex relationship. And if he had been in a heterosexual relationship, he wouldn't have been denied that money. And he's just one person, of course, right? We're talking about now a whole nationwide class of people who have encountered a similar harm. And it is not uncommon for people to have been denied 6 figures in survivors' benefits. And then, of course, there's also the indignity of being told your marriage isn't equally valid as compared to a heterosexual couple's marriage. So just to recap sort of the injustice of the situation, this next slide shows you a timeline of the discrimination at issue. So back in 1971, Michael meets Spider at age 18. At age 54 in 2007, they have a commitment ceremony. Then if you skip over to the green text, you'll see that October 17th is the first day when same-sex couples were able to marry in the state of Arizona. Michael and Spider waste no time, again, in getting married. It's less than 3 weeks later that they get hitched finally. And then Spider dies about 6 months after their wedding. So the federal government has told Michael, essentially, we need you to have been married by August 20th of 2014. That's 9 months before the death at issue, in order to access these benefits. But literally, it was legally impossible for same-sex couples to have married in Arizona at the time. So we filed a lawsuit on Michael's behalf in federal court in Tucson. And I should note that our co-counsel in the case are 2 excellent local attorneys, Brian Clymer and Autumn Menard, who specialize in Social Security. And We had a hearing in the case in March of last year. That is a photo of the federal courthouse in downtown Tucson. And in May of last year, we received a favorable ruling, not only in favor of Michael, but also in favor of the nationwide class. And the federal government had tried to argue in the litigation, has still tried to argue in the litigation, that they just rely on a neutral 9-month rule that does not discriminate. But the court recognized that you can't really separate a requirement like that from the underlying marriage bans that certainly did discriminate against same-sex couples. And just as it's unconstitutional for states to exclude same-sex couples from marriage, neither can the federal government essentially rub salt in those wounds by continuing to rely upon that exclusion to deny people present-day benefits. So the remedy is not everyone gets benefits. The remedy is same-sex couples who are in the same position as Michael and Spider have a chance to prove that they would have married 9 months before the death at issue if they had been given the chance. And some of the evidence that would be relevant to that type of inquiry include, for example, in Michael's situation, the fact that they entered into a commitment ceremony much longer than 9 months before the death at issue. Now, I should also note that the government has appealed this case, and so things are not final. And I will return to that in a little bit. I wanted to also give you a sense of who else is affected by this problem, because as I mentioned, this is a nationwide class. So I'll give you 3 quick examples. This is a picture of our client, Anthony Gonzales, who was with his late husband, Mark Johnson, in New Mexico for many years as well. They married on literally the first day when they could, where they lived in New Mexico. And unfortunately, Mark passed away of cancer 6 months later. As a result of the ruling that we won in Michael's case, Anthony now also has been awarded benefits as well. Another example of a class member is a man by the name of Joshua Driggs. He's also from Arizona, lives in Phoenix, and he was with his husband for more than 40 years as well. And the reason I want to make sure to mention Josh is that he's an example of someone who is particularly vulnerable economically. Because he was denied these survivors' benefits, he had experienced homelessness on 2 different occasions. There was one particularly sad time around Thanksgiving that he had to live in a van in a Walmart parking lot, none of which would have happened if he had had access to the survivors' benefits based on the work history of his late husband. So Social Security obviously is very important to so many people, but for those who are on the margins, it can make the difference of whether you have a roof over your head or not. Let me skip over this slide. The last class member that I will mention, and this may be a little bit surprising to you, is Jim Obergefell himself. So Jim Obergefell, the named plaintiff in the case that the Supreme Court decided, holding that same-sex couples have a fundamental right to marry, is also impacted by this problem. So Jim, who's the one standing, lived in Ohio with his partner, John Arthur, and they were together for more than 20 years. John was diagnosed with ALS, and at the time, Ohio did not allow same-sex couples to marry. So they instead chartered a plane that was medically equipped to transport him to Maryland, where they could marry. And so they married on the tarmac in Maryland. And then John passed away 3 months later. Under this 9-month rule that the government has, Jim will be otherwise, but for the ruling that we obtained, denied benefits when he goes to apply for Social Security survivors benefits when he turns 60. And I just think this is a remarkable illustration of the work that we still have to do if someone like Jim Obergefell still has to fight for equal recognition of his relationship, even though he literally won his case once already at the Supreme Court. So as I mentioned, this case is still on appeal right now. That appeal was started during the Trump administration, and we very much hope that the Biden administration will choose not to continue these appeals. And part of our concern in candor is that these cases may very well test courts' commitment to whether or not same-sex couples get full marriage equality with 100% of the rights and responsibilities, or whether perhaps same-sex couples will only get what Justice Ginsburg called skim milk marriages. In other words, you get the certificate, you get the document, but maybe it doesn't guarantee you the exact same protections as everyone else. And that actually came up, just as an aside, during the confirmation hearings for Justice Barrett, when Senator Cory Booker asked her about Michael's case. And the highlighted text basically gets to the main question of, hey, do you think this violates the rule of equal treatment that the Supreme Court has laid down? And no surprise, we didn't get a direct answer from now Justice Barrett, but something slightly concerning in her word choice was that she said, essentially, it's plain that Obergefell recognizes the full right of same-sex couples to marry, but the question of what are the implications of that for benefits would be something that would come up before the court later. So something of a duck. All right, so as I mentioned, Ely versus Saul is on behalf of same-sex couples who were able to marry, but not able to be married for the full 9 months required to access these really important benefits. The other big piece of litigation that we have, and I will summarize this a little bit more quickly, is called Thomton versus Saul. And so pictured here are our clients, our client Helen Thomton, who is with her late partner, Marjorie Brown. They were Washington residents, and I will walk you through their relationship history as well. So Helen and Marge meet in 1979. Tragedy strikes their family about 25 years later. About 25 years later in 2003, when Marge is diagnosed with cancer. And then Marge passes away 3 years later in 2006. So the problem that Helen experienced is actually very similar to Michael's, where she wasn't able to marry at that magic moment in time that the government requires you to have been married in order to access these benefits. So it wasn't until 2012 that Washington ultimately allowed same-sex couples to marry, which was 6 years after Marge had already passed away. So much like Michael, we filed suit on Helen's behalf, this time in Washington state. Also sought class action status, and the reasoning of the court's ruling in favor of Helen is very similar to the court's reasoning in favor of Michael, which is essentially that the federal government is continuing to double down on unconstitutional marriage laws by giving them effect in the present day. So this is, and again, much like the remedy for class members in the Ely case, the remedy in the Thornton case is that class members get a chance to prove to the government that if they've been given the opportunity, they would have gladly chosen to marry. And it's actually not that hard to figure out whether or not that's true. Many same-sex couples, of course, had conversations with one another, talking about how they wanted to marry. And in Helen's case in particular, she was actually, the couple was actually quoted in a newspaper talking about their desire to marry way back when, because they had fought for domestic partner benefits. And the highlighted text on your screen is a quote from Helen's late partner, Marge, that says, you can't get benefits because you can't get married, said Brown, adding that she and Thornton would gladly marry if state law allowed it. So I will just do one more quick sort of brief overview of some of the class members who are affected by this issue, much like Helen. One class member is another Arizonan by the name of Jim Martin. He lives in Phoenix. Jim was with his partner, Ray Gano, for 37 years before Ray passed away in 2011. And again, that was 3 years before same-sex couples could marry in the state of Arizona. Without access to marriage, they chose to celebrate Valentine's Day each year as their anniversary. And the picture that you see here is from 2004 on their 30th anniversary, when they decided to have a commitment ceremony. And they wore matching necklaces that said meant for each other. And the very last class member that I will talk about before closing things out is a man by the name of Keith Bradkowski. Keith was with his partner, Jeff Coleman, for 11 years until Jeff died in the 9/11 terrorist attacks. They met on August 23rd of 1990, and they chose to celebrate that date as their anniversary. On their third anniversary, they exchanged rings with matching serial numbers, and they considered themselves to be married from that point forward. On their 10th anniversary of being together, Jeff wrote a letter that said, quote, "I love you truly, Keith Bradkowski. Don't ever forget that. And when you're feeling lonely and I'm not here with you, just pull out this letter and read my words to you once again and know how much you mean to me now and always." Jeff was working as a flight attendant on one of the American Airlines aircraft that was hijacked in the September 11th attack. That was in 2001, when no state in the country allowed same-sex couples to marry. And so they too are sort of caught at this terrible crossroads of not being able to access the benefits to which they are entitled. So a lot of heavy stuff, of course, but I think these stories are so powerful because they illustrate the things that we actually have in common. The loss of people that you love is part of life, and one of the most painful things that anyone can experience. And that's true regardless of what your sexual orientation is. That is, I think, part of the reason why the Obergefell case, the Windsor case were so powerful. And the question that we want judges and the public to ask themselves, really across all of our work, is how would you want to be treated in these really dire moments of life if this were you? And I think a lot of our work is about finding that common ground. And I think these cases are a really powerful illustration of the things that we actually all share in common. So that's it for me. That is in a nutshell the work that we've been doing. I have a plug here for our help desk in case anyone has any other legal questions, but I'm also happy to answer any questions that folks might have. I breezed through a bunch of that really fast about the cases.
There's a
Peter,
question in the chat. Oh, sorry, go ahead.
Yeah, Peter, I'm looking at the chat and there's only one, and it comes in from David. He says, what are your chances on appeal now that Biden and the Biden administration are in power? Will they drop the appeal? You touched that briefly, but David wants to know more.
That is very much our hope. We are urging the Biden administration not to continue defending what we view as discrimination. And it remains to be seen what will happen next. The appeal in the Ely case in particular, as I mentioned, was started by the Trump administration. The government has not yet spoken in the Biden administration. So in other words, their substantive brief is not yet due. And TBD, I will say this is the type of thing that keeps me up at night. I really hope that we don't have to keep having this fight. This feels like something that should be low-hanging fruit for an administration that has really prided itself on being allies to our community. But the reality is we have to hold even our friends' feet to the fire to get them to do the right thing. And so that's part of the job of Lambda Legal, and that's what we're doing. So too early to tell keeping our fingers crossed, and that they will stand down from defending really what is a legacy of discrimination.
And Peter, Sally asks you, can you please explain what you meant by the milk clause in reference to Ruth Bader Ginsburg?
Yeah, sorry, I was going so fast on that part. So, there was a very memorable line that Justice Ginsburg had during oral argument in the Windsor case. So the Windsor case was about the federal so-called Defense of Marriage Act, which basically said, even if you are married for state law purposes, the federal government will not respect your marriage. And so Justice Ginsburg posed a question during the oral argument that essentially said, what are same-sex couples left with? Do they get just skim milk marriage as opposed to sort of full fat marriage with all of the rights and responsibilities that heterosexual couples have? And so in a sense, that's also what's at issue in these cases where, for example, Michael Ealy, he has a marriage certificate, but the question is, does he get access to all of the stuff that comes with marriage, like Social Security survivors benefits? And if not, then he's really left with something that is less than the full-fledged marriage that heterosexual couples have always had access to.
And Peter, Bonnie wants to know if you would please repeat the names of the Tucson lawyers who specialize in Social Security issues.
Absolutely. So their names are Brian Clymer. I will actually type this into the chat, and Autumn Menard. And if you have questions about Social Security and you are in Arizona, they are your go-to people.
Peter, David is asking, thinking about Roe v. Wade, what do you see as the future of your precedents? What kinds of attacks do you anticipate from state legislatures?
I do think that probably the area that we have the most to worry about is the watering down of marriage. I think that the odds of a total reversal of Obergefell, for example, knock on wood, is not particularly high. Instead, I think what we have to be on guard for is more death by a thousand cuts, where they start chipping away at sort of the full respect that same-sex couples have for their marriages. One example of that concretely is even after Obergefell, which was in 2015, there was litigation out of Arkansas about same-sex couples' parenting rights. So the issue there was that Arkansas would give birth certificates to married heterosexual couples where both of them were listed as the parents of a child, even when the husband was not the biological father of the child, because the couple had used donor sperm. And yet, even though they would give that two-parent birth certificate to heterosexual couples, they would not give the same two-parent birth certificate to same-sex couples. For example, in the case of a lesbian couple who also used donor sperm to conceive their child, they would only list the biological mom, but they wouldn't list the non-biological mom on the birth certificate, which is obviously discrimination. At the point that biology doesn't matter for a different sex couple, why would you be holding same-sex couples to a different standard? And so that case also went up to the Supreme Court. And surprisingly, it was not a unanimous decision. The couple won, and thankfully we have even more precedent that says, yes, when you have to treat same-sex couples equally, it includes with respect to the stuff that comes with marriage. But even there, I think it was a 6-3 decision in that case called Pavon, where there were a number of justices on the Supreme Court that would have ruled the other way.
So at this time, there's no further questions in the chat. If anybody would like to ask a question, you can raise your hand and Beth will call upon you.
Joanne.
Since we have a legal expert here, I'd love to hear your take on what the Supreme Court, and what do you think is going to happen in general going forward over the next couple years with our newly minted, very conservative court?
It's a great question. I think that we will see, unfortunately, an increasing erosion, most likely, of many of our rights. And again, I think it may not happen overnight in one fell swoop, but I do think that there will be continued attacks on the rights of our community. You know, one case that I think illustrates that so concretely is currently pending before the Supreme Court. It's the Thomton case involving whether or not the city of Philadelphia can basically enforce its non-discrimination requirements in the context of adoption. And the issue there is that Catholic social services, basically the religiously affiliated child welfare provider wants an exemption from the general non-discrimination requirements. That case was argued last year. A decision could come out at any point in time. And I don't think, unfortunately, that there is a ton of optimism about how the Supreme Court will potentially rule in that case. And that is sort of the tip of the iceberg. We will see other iterations of this same issue come up again and again. We saw it once in the context of public accommodations involving services and goods to same-sex couples who are looking to marry. This is the issue with the bakers and the florists and the refusal by businesses to treat same-sex couples equally. So there is, I think, a lot of reason for legitimate concern. At the same time, you know, fortunately, not all of our cases actually result in Supreme Court precedent. Many times, actually, the usual course is that they get resolved at the lower court level. And so as much attention as we pay to the Supreme Court, we should also be focused very much on what happens below that stage, because that is where most litigation ends up getting resolved, in all honesty. And so even if we can't dramatically change the composition of the US Supreme Court, there is a lot more that we can do with respect to the lower court composition. You know, Trump did a very, very good job of really stacking the federal bench with people in his image. And I think there is a moment right now when some rebalancing could occur in the lower court seats as well. So that's something very practical that I think that many people will be focused on in the next 2 years.
All right. Thank you all for being here. Thank you, Peter, very much for an informative and accessible presentation. I really appreciated your PowerPoint a lot. That visual made a huge difference to understanding all the timelines about what you were dealing with and what all of the people are dealing with that you're working with. Everyone, thank you for being here. And please, I think that I put the Senior Pride website in the chat again. Please note. And Bob, take it away.
I just want to say to all of the participants who registered and joined today, thank you for being here. I'll be following up with each of you by email in the coming week with a link to the recording of Peter's presentation today, and also for how you can be involved in support of Lambda Legal and the important work that they do. So thank you. Beth, to you for close.
Yes, thank you so much. I hope today gave you an appreciation for just a little bit of the work that Lambda Legal does, and in Arizona specifically, so that has relevance to all of us. We couldn't do this work without you. And this is why Jill and I are not only donors to Lambda, but we have remembered Lambda in our estate plan. And so I invite you to make a contribution to Lambda Legal today, or when Bob follows up, I put a little link in for this event to a website for our One Lambda fundraiser. You can always let me know if you had any trouble, but we really appreciate it. I also want to thank Bob for hosting and arranging this event, for Lavina for making this possible as far as having a website for registering, and dear Peter, for your time, which is so valuable to us, and we appreciate the touch and the accessibility. So thank you all for joining us today. Enjoy the rest of your evening. Good day.